Hello viewers, my name is Trusty Freddy.
And I am Justice in Field.
Welcome to our program, Voice It, where we discuss topical issues. And today we are talking about the newly gazetted Cybersecurity and Data Protection Act.
Yeah, this is a particularly interesting act which has been in the rounds for some 5 years.
Yes.
And debate has been ongoing concerning what it has to offer to the Zimbabwean citizen. But basically, it is now here. It has been gazetted on the 3rd of December 2021. There is the general feeling that the instrument is good for the people. What has been some of the views?
Yeah, you know, Mr. Justice, it has hogged the limelight for the past few days. And some are saying it is being weaponized, it's being used for political expedience. But we don't want to talk much about this. Let us leave it for the experts in the legal fraternity and in the media fraternity.
Indeed, we interviewed people from the League of Fraternity. From the League of Fraternity, we had Mr. Tabora,
Yes.
a doctor, a very professional person in the industry. And also in the media industry, we interviewed Dr. Ruhanya, and he's going to share his thoughts on what they feel about this particular instrument, which is a newborn baby in the media industry.
So when we started the introduction, what is the name and how do you prefer to?
I'm Dr. Tabora, law research.
Dr. Tabora. Thank you, sir. Thank you for the time. We are looking at the cybersecurity and data protection bill that is recently been gazetted into law by His Excellency. What is your general feeling concerning the bill which is now in
What I want to say is maybe most countries have that legislation. So it's not only us, most countries are now passing that kind of legislation because we are living in the information age where data is all over the place and there must be laws on data protection. Also, we are living in an age where cyberspace is now a hive of activity and there's no way that we cannot regulate that space as well. So to me, I think it's a very necessary bill. Also, it's a response to global technological developments. It's a response to also what other countries have done. So I think it's welcome in Zimbabwe.
Some are saying that the bill is an infringement on the freedoms of individuals to express themselves. What are your feelings?
Most laws try to give effect to a particular objective, like a national objective. In this case, separate and secure persons. People do not want it to be in danger because of their data. That is in danger of many organizations like Google, many data mining companies. So because of that need, you have to balance the national objective of safety and security with individual rights. Most laws try to limit the fundamental rights and freedoms in the Constitution. So those rights are not absolute. They have to be limited in the interest of the public good. So to me, I think the limitation is necessary, justifiable, as long as they do not, as long as the limitations or restrictions do not destroy the whole freedom. Right? They must be justified and necessary. In the context of what's happening, people are now in danger because of data, people are in danger because of cyberspace. So we need to regulate that speed. And in the fight to regulate it, there is no way that we will leave certain rights absolute. So I think there is a balance. And the bill tries to strike a balance between safety and security of persons and also the fundamental rights of persons to privacy, to security, to information, to other things.
It is an undisputable fact that the students or the youthful population are the ones who are mostly on internet and cyber spaces. Do you feel that there was enough effort to engage the students, particularly we are at a tertiary learning institution? Do you feel that there was enough effort on the part of the legislators to engage the youthful population in their thoughts about this?
I don't think there was enough information. I don't think there was enough effort to engage students, for example, at universities, because usually Parliament do not really make an effort to look for students when they are passing laws that impact on students. But I understand there were massive discussions and debates before this bill was passed. I think this is like the fourth year or fifth year when this bill was on the books and it was being debated in Parliament. And there were some town hall meetings that were taking place. The parliamentary portfolio committees were working on the bill. So I think they invited everyone to give comments, but they did not make an effort to go to particular youth sections, such as students. But I'm very sure I've been involved in the bill before. I'm very sure that there was massive invitation for comments from the public. There was massive engagement of civil society. For the past 5 years, they were debating on it. So it's not a new thing that we're finding. Right? It's something that was always in the cooking pot. But now that they consider it well cooked up, it's not in the parliament. But you can say that in as much as the youth are affected, yes, mostly, I don't think that will be the effect that will remain so in the next 10 years. Everyone will be affected by the bill. Not only users of the internet, but everyone's information on the internet. So everyone will be affected almost equally. So I think everyone is everyone is affected and they should be affected.
In light of the fact that everyone is affected, do you feel that, because there are some sections of society who feel that this is going to be used as a political weapon to crack down on political opponents who use social media and internet to express their views? What are your thoughts?
Yeah, the act is that opportunity. Every law can be abused by the government to achieve its own interest. Every law that is being passed by government can be abused against its two objectives. The government can hide its other nefarious intentions, right, in passing a law, and then give you only the good reasons. Every law can be abused. Criminal law can be abused whereby government can target opposing politicians for criminal cases, isn't it? Media laws can be abused to shut down newspapers. Cybersecurity bill can be laws can be abused whereby information is milked from individuals, stored and then released to mysterious people. So yes, the bill offers that chance, but just any other law, it's just like some other laws that can be abused. Not the only one. We have seen this in African governments where like laws are abused easily beyond what people thought they were going to be used.
As we wrap up, in a word, what would be your advice, hopes, and what are your general feelings and hopes towards this act and the students? What are your thoughts? What do
Students
you
must
give
know
them as
the act.
advice?
Students must know the act. They must discuss the act. They must go to court if they think that some provisions are unconstitutional or impact on their freedoms. They must challenge the act, some certain parts of the act, if they think that it impacts negatively on their well-being. But I think with a good constitution, we can test the constitutionality of the act based on the constitution. Right? So basically, my hope is that it's a new law. So you don't expect Parliament to do a perfect law. That's why laws are amended until they are good. Right? So I'm hoping that as a start, it's a good law. But gradually, bad parts will be evident. There will be challenging court, Parliament will amend. The court will also try to make sure that there's no abuse. Yes. That's basically just about my hope.
So we're no longer what it is about, but the president was recently signed the cybersecurity bill which says him and the cabinet have agreed that this is a piece which is necessary for the Zimbabwean people. What are your thoughts concerning the content and the purported and the rule concerning the cybersecurity bill?
you need to understand the law in the context of how the state is. Because the nature of how the state is governed, or the nature of the regime, or the system of government, assist you to understand the intentions of the bill. I think that the bill's major intention is to crack down on civil disobedience or in online applications, to muzzle citizens on online applications. There are quite a number of citizens that have been arrested on the basis that they were communicating things that were not favorable to the government. So because we know the history of the political system that we have and how they use the law to oppress, how they use the law to muzzle people, I don't think that the intention of the bill is to democratically regulate the excesses of online discussion or online crimes. Yes, of course, we know that in the wrong hands, digital platforms can be used for cyber crimes. Digital platforms can be used for terrorist activities. They can be used for spreading alarm and despondence. But in the case of Zimbabwe, we have not had a situation where digital platforms have been used for criminal activities of terrorist nature. Because one of the aims of that bill is to curb terrorist activities online. But we all know that when it comes to issues of terror, that is violence, public violence, even on Twitter, even in speech, it is related to the people who are linked to the system. We have seen, for instance, when officials from the ruling party who are online saying also that some publishers are against people that they not agree. So it is best understood in circumstances where we have a democratic government. But if you look at a broad level, yes, we have also seen where data that belongs to the government and public institutions have been hacked. In the case of the United States, where several times American systems have been hacked by Russian hackers. So in that instance, where you have a democratic government working to protect state institutions and public institutions, yes, that view such things would be commendable. But in the case of Zimbabwe, we instance where we have not seen terrorist attacks using the cyber platform.
So there's an argument that some are bringing to light that the traditional media and other forms of media, whatever it is, the print, the broadcast, and also the traditional media in its instance, it has been regulated over the years through censorship and other forms of influence. So they say, now with the advent of the new media, which is the internet per se, in general, it needs to be regulated as a way of containing these issues of cyber.
No, there's no doubt that the media needs to be regulated. And the provisions for regulation of the media is contained in section 61, subsection 5, A, where it is clear that freedom of expression and the freedom of the media. Freedom of expression and freedom of the media exclude incitement to violence, advocacy of hatred or hate speech, malicious injury to a person's reputation or dignity, or malicious or unwarranted breach of a person's privacy. So these are limitations that are given to the freedom of the media. But the problem is this the intention of the government to make sure that they protect these exceptions? We agree that freedom of expression has not yet reached what is called a peremptory norm of international law or use conscience. That is, it is not yet general state practice that the media is implementing. But the limitations that are placed on the freedom of the media, both the old media and new media, must be justifiable in a democratic society. And you go to section 86 of the Constitution called the limitation of rights or limitation of fundamental human rights and freedoms. They call it the limitation clause. And say the fundamental rights and freedoms set out in this chapter must be exercised reasonably and with due regard for the rights and freedom of others. The fundamental rights and freedoms set out in this chapter may be limited only in terms of a law of general application, and to the extent that the limitation is fair, reasonable, necessary, and justifiable in a democratic society based on openness, justice, human dignity, equality, freedom, taking into account all relevant factors, including the nature of the right or freedom being concerned. So the limitations that are put even by the cyber security must be fair, must be reasonable, must be necessary, and most critically, they must be justifiable in a democratic society. So these limitations that are in the Cyber Security Act, are they justifiable in a democratic society? What informs the enactment of the Cyber Security Act? In fact, if you look at the history of Zimbabwe and contemporary politics in Zimbabwe, the most violent groups are not groups outside the control of the state. These are groups that are within the ambit of the state, and most importantly, the state itself is violent.
So, looking at the constitution vis-a-vis what is going on, do you feel that it is too late to advocate for? Do you feel that it is too late now for there to be a correction of the intentions of this bill, which is now?
No, what will happen is that you need a constitutional challenge. I think it will be challenged. Yeah, using section 85 enforcement of fundamental human rights and freedoms. If people or individuals or people acting on behalf of a group of citizens or with particular interest think that the Cyber Security Act violates their fundamental freedoms, it will be challenged, and there will be a test case against the excesses of that bill. That I am sure that it will be challenged, because we know it will be deployed as we go for elections. And fundamentally, they would not want, for instance, people to post the results of elections because they want to manipulate elections. They want to operate under the cover of darkness, without transparency, without accountability. And that is one of the main purposes of that bill. It does not promote fundamentally even the security of the state, but the security of the human political idea.
The Media Institute of Southern Africa, Mr. Zimbabwe, has been advocating for the repeal of this illegal before assigning to
how can they repeal a bill that is not law?
So
you can only repeal an act of parliament.
Yes.
So before it was a bill, how could it be repealed? What they should have advocated for was to make sure that it is democratized, because not everything is bad in that law. Yes, we know, for instance, if you look at the case of Rwanda during the 1994 genocide, incitement to hate speech where they were calling minority Tutsis cockroaches. That is not in the interest of freedom of expression. So if the bill is attempting to address some of those things, it is not necessary because it's contained in the Freedom of Information Act, also supporting section 61, subsection 5 into D on the exceptions on the exercise of freedom of expression. So this bill is not necessary actually.
So speaking to the general citizen, the university student, what would be your advice concerning this?
If this bill violates the fundamental civil and political rights as contained in the Declaration of Rights, Chapter 4 of the Constitution, there must be a test case. They must approach lawyers like the Zimbabwe Lawyers for Human Rights and do a test case to challenge the constitutionality of particular sections that they think they offend the Constitution, and they can take it to the Constitutional Court.
There you have it, viewers, from the professionals. Viewers, I'd like to advise you to familiarize yourself with the newly gazetted act, otherwise you plunge yourself into trouble. Please don't forget to subscribe to our YouTube channel, Street Eye Media, so that you don't miss the next episode. It's just Freddy signing out.